Kavanaugh.
A couple things just to clarify. Uniquely federal interest branch of preemption is a separate doctrine from Boyle, right, or a pre-existing doctrine.
Yes, it predates Boyle. The court has continued to recognize it as being appropriate. I think that Boyle applied the doctrine.
Right, it's not a new
thing. It wasn't new then, and it hasn't been disavowed by the court since then.
On the field conflict terminology, I want to get your understanding of what counsel said, which is my understanding is he said when there's an inherent conflict in a particular kind of area, you can call that field, and Garamendi footnote 11 and other cases in the court's jurisprudence have essentially said that. Is that your understanding, or do you have a slightly different understanding?
In our brief, we said we think you could think of this in either way, but if you had to pick, I think I would say that it's a form of field preemption, and I think that that's because we're talking about an area, overseas combatant activities, that is so uniquely federal. The whole area of it should be considered something that is beyond the scope of the states because they've been divested of their powers in this context. And that's consistent with the way the combatant activities exception in the FTCA itself is phrased. It's just everything is out. No suits arising out of combatant activities. There's not a bunch of nickel and diming about exactly what's in and what's out. That's different from the discretionary function exception conditions that the court considered in Boyle.
We've talked about states, in Justice Kagan's question, states that are trying to supplement or help ensure that contractors comply with their obligations. The rule on the other side, though, I think would apply equally to a state that's hostile to the United States' war effort, which states sometimes have been in terms of opposed to the Iraq War, opposed to the latter stages of the Afghan War. Is there any difference there? I mean, how do we think about a hostile state? Hostile might be too strong a word, but a state that has laws that is trying to impose different obligations on the United States' conduct of war than the United States itself is trying to impose.
Yeah, I think that my friend already conceded that would probably fall because it's a discrimination against the government and it's treating the government differently.
Well, it could be applying a neutrally applicable law, however.
Well, I guess there could be a question of if you thought that—
You're not concerned about that?
I'm not concerned if you adopt our rule, which would say that combatant activities
if we adopt their rule, are you
here.
worried about the state that's not supportive?
Yes, we are concerned that, as I said, we're worried either way. We think that the imposition of the threat, the specter of tort liability, is affecting the relationship between the government and its contractors in a war zone, and we don't want that interference.
And what about the Afghan law? So the state choice of law rules lead to Afghan law being applied in a suit like this, and who knows what that leads to. Do you have a concern about that, or is that not a concern?
That is a concern. And I think that I'm not exactly sure what the party's answer to that question really is, because there wasn't that much focus. The Fourth Circuit has just a footnote on the assumption that South Carolina law was applicable here, and I understand my friend on the other side to be saying that they're standing on the background idea that the common law applies, and I guess they mean state common law instead of, the brooding omnipresence in Afghanistan.
Well, some courts have applied Iraqi law or other foreign law in these kinds of situations, correct?
I don't know about combatant activities situations, and there may be public policy reasons not to apply foreign law in certain instances. That's really a conflict of laws, choice of law question. And as a general matter, this court has held that federal court sitting in diversity has to apply the choice of law rules for the jurisdiction in which it is sitting. And so, we are looking to state courts then in order to select the rule of law. I think that's a reason to say field preemption. Let's not let that dictate what's going to be the standards at issue in this case.